very good to be here. Tonight, our toast will be to our outgoing district governor, Ian Sullivan. For a great year, Ian, thank you very much. I hope you enjoy the roast on Thursday night and that we're still friends when it's over with. But you had a great year. God bless. Chink, chink.
Salud.
Salud. Tonight we'd like to talk about a subject that's important to a lot of us, and that's the importance of estate planning. As an attorney, a CPA, and a financial planner, I work with individuals in settling estate matters and to determine what needs to be done in estate planning. And I'm amazed at the number of folks and members of our very club who said, I don't have a big enough estate to worry about all this stuff. And the thing is that we all have stuff, and we all have estates, and we all probably have a reason to plan for estates. So I'd like to just give a quick conversation of what do we need to look out for, what's important to us, and how do we go about doing it. Now, many people think of estate planning as how do I transfer my assets to my heirs at my death, making sure that children get things that you want them to get at the right time, in the right way. And I have folks who are most concerned about making sure, especially when they have young children, that money goes to a trustee that can manage the money for the child and the child has an appropriate guardian. But even after the age of majority, there are a number of folks who are concerned that the age of majority as recognized by the state might be too low for the age of reason. I'd just like to ask the group here, when do you think a child reaches the age of reason?
50?
50. 40. And I guess it depends. Are we talking about a boy or a girl? I think most of us agree it's probably not 18 years of age. And for some folks, they're most concerned about not giving too much to a child, not giving so much that the child does nothing, or at one time a child cannot handle the money. But even after a child is in their adult life, in their 40s and 50s, there are still times when we might have concerns. I have clients who have children with special needs, children with Down syndrome, or who will always be dependent. Children who have special needs and don't have special needs, if you know what I mean, and special needs. I have clients that have children that have drug addiction problems, perhaps. And I had a gentleman that said he loved his son, but he didn't want to leave money to his son for his son to kill himself with. And after several clinics and rehab centers, his son could not stop doing cocaine. So he wanted to make sure that we left money and didn't necessarily disinherit the son, but didn't leave him a lump sum to kill himself with. Or I have a gentleman who loves his daughter, but said that as much as he loves her, he doesn't trust the guy she dates. He's afraid that some smooth-talking guy will come along and take away all the money. So planning for our heirs, even after they reach the age of majority, our age of reason, becomes a big concern for a lot of folks as they do their financial planning and doing their estate planning. The concern is making sure that our heirs receive money at the appropriate time and in the appropriate way, and protecting our heirs from maybe even their own spouses or their own spendthrift habits. But I see some of the most important parts of estate planning for protecting us during our lifetime. Much of estate planning is involved with deciding who will make decisions for you in the event of your incapacity. And I know for a married couple, they always say, my spouse will take care of me. But after your spouse, the next question gets kind of deeper. Who will it be? Some say my oldest child. Others say not the oldest child, the one that's more reasonable. And others say, no, the children are still too young, or they don't think like us, or we don't have kids. So who's in line to make financial decisions to take care of things if you can't, and then make the medical decisions if you cannot do it? This played an important role in my own family when I went home to see my folks that had retired in Mountain Home, Arkansas. I went to Mountain Home, Arkansas because it's a pretty retirement community. Didn't know anybody in Mountain Home, but there are a lot of retirees out there. And I remember going to visit my mom a few years back, and I was in the house for maybe 20 minutes. We exchanged pleasantries, and then she said, Bill, I want you to make all that stuff legal. I'm like, well, we've been talking about doing this stuff for years. What happened? And she said the neighbor down the road had a stroke, and her kids swooped in and threw her in a nursing home. sold all of her belongings, and left her here. And now the church is trying to pay her nursing home bills until she qualifies for Medicaid. She said, I don't want that to happen to me. I'm like, Mom, that'll never happen to you. You got us for kids. He said, how do I make it legal and make sure of it? And I said, okay, just fill it out, list what you want, put it in writing, and we'll legalize it for you. Well, a few months later, when I went back to visit my mom, she had put it in writing. And she was extremely detailed on what she wanted done. I mean, she did some of the things you would expect. She said that if she became disabled, she wanted to stay at home for as long as was practicable. Which makes sense, I guess. But then she also got down to the nitpicky details, as only my mom can do. She wanted to make sure her hair was brushed every day. I don't know, she wanted to look out the window with that witchy hair or something. She wanted to make sure she went to church every Sunday, even if she didn't know what was going on. As long as she wasn't a nuisance to anybody else, she wanted someone to take her to church every Sunday. She wanted to go to all the family reunions. We don't do them too often, but like every 5 to 10 years we'll do a family. Even if she didn't recognize the folks, she wanted someone to take her to the family reunions, and she wanted to be present. And I was going through, I'm like, Mom, do you know how much all this is going to cost? He said, you told me I could do it. I'm like, well, you can, and we'll do it. But she got down to the very details of at death. She didn't want to be buried. She wanted to be cremated. And the kids would have, my brother and sister and I, we love each other, but we don't always think alike. We would have argued on that point for days, months, and maybe years if we didn't come to the right decision, because none of us would have guessed. She wanted to be cremated, and she wants her ashes scattered off the coast of Kauai, Hawaii, because it's the prettiest place she's ever been. And once again, I'm like, Mom, do you know how much it's going to cost? And she said, yeah, but instead of spending money on a funeral, I want you 3 kids to have a vacation and celebrate my life. I'm like, great. We'll probably have to chant to Pele or something. I don't know. She's always a flower child. But she's going to get it. And that's my point. Because we would have never thought of it, and we would have had some problems. And I've seen many families come apart because details were not relayed before death. And I've seen so much stress and confusion and dishonesty in normal families where they get along fine. But you combine a death of a parent plus the family upbringings, it can become overwhelming. And a lot of the issues can be eliminated by proper planning on the front end. So I think that is just as important. How do you take care of things during your lifetime, and how do you keep peace in the family? I think that's as important as what most people think of when they talk about estate planning. Now, several issues here. A lot of folks have always been concerned about taxes. And yes, taxes do come into play at death. There's a final income tax return. You don't get out of income taxes just because of that. There's still an income tax that needs to be paid. And tax on distributed 401ks and IRAs are going to be taxable at the ordinary income tax rates, unless we structure a beneficiary that's an individual to receive these dollars. And then the individual can take over the IRAs and not pay tax. For years to come. They can do required minimum distributions going forward. Heck, a spouse can take it over as their own IRA. So naming beneficiaries becomes important to avoid some of the tax. So income tax, yes, there will still be income tax. A lot of folks for years were concerned about the gift tax. Have you all heard before that you can't give too much money or you have to pay tax on it? What was that number when you all were growing up? It was $10,000. Y'all know what the... Well, it's $14,000 a year now. So it's gone up. But you almost have it, Rick. What happens if you give away more than the allowed amount each year? Well, there's a lot of tricks to go through. First, I could give $14,000 to my son. And my wife can give $14,000 to our son. So together we can do 28. And if he's married, we can do 28 to him and 28 to his spouse. So we can give away a whole lot of money in a lot of family situations before you even have to worry about exceeding the threshold. But if you do exceed the threshold, what terrible thing happens? I have a lot of people say, well, taxes will be due. When are taxes due, Rick? Well, if you exceed the threshold, you have to file an informational return with the IRS. So whatever you give, minus what you were allowed to give, is your excess amount. And if you give more than your excess amount, you have to complete a form to track how much excess you've given every year along the way. And when your excess amount exceeds $5.2 million, then you have to pay some tax. Now, I might be a generous guy, but I'm not giving $5.2 million away. So giving more than the allowed gift amount each year is really no big deal, but you hear about it all the time. And I hear some people say, well, don't tell my kids that, because that's the excuse I always give them to say, you're just getting $10,000 this year. So the gift tax is the other piece of the puzzle. Likewise, the estate tax has been raised to where we don't have to worry about estate tax unless we're giving more than $5.2 million per person. Now, it used to be that if you gave more than $600,000 through estate, that you had to worry about estate tax. And a lot of people had more than $600,000. Heck, you had the house and the 401ks and your investments. $600,000 was not a high threshold. And the tax rates started at 35% and quickly went up to 55%. So people were giving them half of what they were leaving. So people created these fancy bypass trusts in their estate plans. However, under the current rules, it's $5.2 million per person, $10 million per couple before you have to worry about estate tax. So the estate tax piece, which people made a lot of hoopla about, that a lot of trusts have been prepared for, and inside of wills, they're called testamentary trusts because they come about as a result of the will. Many people have testamentary trusts that no longer provide a benefit, and they encumber the surviving spouse. And I work with clients all the time. Their parents passed away, and there's a trust that suddenly came into creation, and the trust was not optional, it was a requirement, and now they're setting up a trust that provides no tax benefit and encumbers folks. Used to be, we were willing to pay some headaches on trust if we could save hundreds of thousands on tax. Now, no hundreds of thousands saved, and you still have the headaches of the trust. So the taxes are not as big of an issue as what you may have heard over the last several years when you couldn't give away too much money and we had to worry about estate tax. Now, key issues. How many of y'all have a will? Everybody here have a will? We'll draw one up. You know, I've seen a lot of folks put together wills or go online and get wills, and it's better to have wills that are in the language of the state that you reside in. But most states will recognize other states' wills. If you do it yourself, make sure that you have a self-proving affidavit to your witnesses so they don't have to find the witnesses after you're long gone. But I think most people know how to put a will together. But what a lot of people seem to not realize is the will is the last way in which money is transferred. Money is transferred in 3 other ways first, and if money isn't transferred in one of the other 3 ways, the will finally transfers assets. The other ways are, number 1, we've already talked about, that's your beneficiary designations. When you name your beneficiary designation, your 401k, and your IRAs, and your life insurance policies, your beneficiary designations take precedence over the will. I've seen folks forget this. They'll be filling out their paperwork at work, they name their spouse as their beneficiary, then when it comes to contingent beneficiary, they name their oldest son. The will says, I want to leave my money to my 3 children equally, but the beneficiary designation left everything to the oldest son. It's a mistake. It's an oversight. They thought the will would dictate, but the will is last. The beneficiary designation is first. So we want to get our beneficiary designations right and up to date. In addition, on those beneficiary designations, if you had 3 kids, list all 3 of them. I had a gentleman that had 3 sons, had 3 jumbo CDs, listed 1 son for each jumbo CD. Figured that was easy. That was $100,000 for each kid. And then he spent one and forgot about it. When he died, the youngest son's like, what did I do wrong? I was like, well, Dad just forgot. That's the way he set things up originally. It's better to name each child. Name them equally. 33%, 33%. Give your favorite one 34%, but name all of them in percentage. The second way that money transfers is by operation of law. and that is joint with right of survivorship. Joint accounts. We all love having joint accounts. Joint accounts with your spouse is kind of comforting. But many mistakes are made when parents put their children on joint with right of survivorship. Problem number one, had a situation where a woman was having a hard time balancing her checkbook, so she put her oldest daughter on the checking account. She took her down to the bank to get her put on the checking account, and instead of putting her on as a signatory, they put her on joint with right of survivor. When mom passed away, the oldest daughter got the checking account plus about $300,000 of CDs that were related to that account. And this lady didn't have a lot of money. That was most of what she had. She had that in the house. The will said, I leave my money to my 3 girls equally. What do you think the oldest daughter said? She just got $300,000. She got most of it. She should have said, Mom made a mistake. She should have put me on as a signatory, but no, she said, Mom knew what she was doing. I was the one taking care of her. Y'all were out having fun. I was here balancing her checkbook. Y'all can have the house. She didn't want to have the house. Y'all can have the house, and I won't even take any of that. That becomes a difficult situation. In a situation like that, we had to call the family in and get the oldest daughter to disclaim her portion of the inheritance. Do you know how hard that is? Oldest daughter to say, I give up my share to my siblings. I mean, that's when you hear about who didn't get the big Bertha doll at Christmas when they were 10 years old and things like that. There's a lot of family emotion that comes up. Fortunately, she did, but that could have been avoided. I had another situation where a lady put her son, joint by survivorship, one son, figured to bypass probate, make things a whole lot easier. Problem is, the son was then involved in an auto accident, and he'd been drinking. And it wasn't the first time. And a personal injury attorney was able to get a judgment and freeze all the accounts with his name on it. Unfortunately, her money had his name on it. She's like, didn't even think about the risk. You can do what's called payable on death or transferable on death assignments on these things by operation of law, not joint with right of survivorship. So joint with right of survivorship is another way in which money transfers. It's fine with spouses. It's fine if you use it appropriately. But oftentimes with children, it's a mistake to use a joint with right of survivorship. And the third way in which money transfers is through the use of trusts. I work with a lot of folks who have family trusts. They create the trust, put all their assets in the trust, and the idea is at death there's no probate, there's no work to do. The trust gets a new beneficiary and a new trustee. And it's very efficient. And it works great, especially if you have property in other states. The heirs don't have to go to Florida and to Montana and to the other states to do mini probates in those states. They can just transfer the trustee and the beneficiary. It's easy. In some states where probate is onerous, I highly recommend these types of trusts. Fortunately, in the great state of Texas, probate is relatively painless. Can be done in how long, Lisa? You've done a few of them?
About 3 months.
Okay. Less than 90 days, we can get through the entire probate process in Texas for a normal situation. If we don't have businesses that have to be appraised or property in other states or contesting of the will. But under normal circumstances, Texas isn't a tough state. And there isn't a percentage of the assets you pay. Texas charges less than $300 to admit the will to probate and to go through the processing. But other states, they want a percentage of everything you have. So you don't want to go through probate in those states. But here, a trust is kind of an optional document. So knowing that those are the 3 main ways in which money transfers eliminates a whole lot of the major mistakes that people make. And people create trust to have control of the assets beyond the grave. I talked about earlier, the gentleman had the son that was chemically dependent. That's a nice word for drug addict. He couldn't stop doing the cocaine and had gone to a few clinics. Dad set up a trust where he didn't want to disinherit his son, but his son had to pass a drug test each month to get his monthly distribution from the trust. And if the son didn't pass the drug test, the money went to charity. And I figured that charity's going to do pretty okay. No, I shouldn't say that. But it was an interesting way to try to curb behavior. The gentleman who was concerned about his daughter marrying the wrong person who would take all of his money. He was able to establish a trust in which the interest was distributed each year, but never the principal. It would continue to give, and the amount that it gave, provided there was a growth rate on the investment, would increase every year. So it's a gift that kept on giving. And if she was involved with somebody that took the money that came out each year, he could have the annual income, but he was never going to touch the principal. And that was a protection for his daughter. I had another gentleman who didn't want assets pledged by his son's business dealings. He was afraid that son would get into a business deal and lose everything. So the assets are not pledgeable within a trust, but were available for health, education, maintenance, support, and anything else that the trustee, which was the boy's uncle, determined was necessary to keep him in his lifestyle, but not for business ventures. So there are a lot of ways to protect and control the assets with trust. The key concerns with doing a trust is there is an additional tax concern with trust. You want to make sure assets are distributed. You do need to involve the attorneys in preparing the trust on the front end. We're looking at usually $1,000 to $3,000 to set the thing up, annual expense to maintain it, and having a trustee. And if you use a corporate trustee or an outside trustee, the expenses can be several $1,000s per year. But within families and having family volunteers as trustees, we eliminate a lot of those issues. Anyway, that's all I had to say tonight about the basics of estate planning. Any questions from the group here?
Yeah.
Yes, sir.
Okay. So let's say your mom sets up a trust for you. To pass her assets to you in the form of a trust. Is that then if you're a beneficiary or a trustee of the trust, is that joint marital property?
Fortunately not. Inheritances are never considered to be marital property unless you commingle them. The state of Texas, even though we're community property, if you receive a judgment for personal injury, it's separate property. Anything you came into the marriage with, provided you don't commingle, it's separate property. And anything you inherit is separate property. And if you have a trust, that's already so separated that that is not commingled. And that is kind of the concern that the guy had about his daughter, because he was afraid that she would get involved and be divorced, and the rules would work against her, and that the family assets would be lost to somebody else. So that's a protection. Number one, these basic documents that we need in doing estate planning are going to be your durable power of attorney, which tells who will handle your financial affairs if you are unable to do so. Your medical power of attorney, which is who will make your medical decisions, with the corresponding HIPAA authorizations, the will, and the directives to physicians. That's the minimum 5 documents that each person should have. Beyond that, then we have trust and disposition of remains and other ancillary documents that make sense. Disposition of remains, like my mom wanted to be cremated. My little sister says the good book says bury the dead. She would never go for it, but mom has said what she wants to have done. I think that's interesting because for some families, it's a big deal what happens. And families oftentimes spend too much money. So those are the basic 5 plus other documents make good sense. Now, here's the challenge. I've had a number of folks who put all these precious documents hidden away so nobody knows who's going to be the attorney in fact on the durable power of attorney, who's going to be the executor of the will. And so it's a big surprise to everybody. And the problem is sometimes they can't even find the documents. In fact, when I have clients, I ask them to bring their documents in for a review, I have folks say, we couldn't find them. I'm like, if you can't find them, how do you think anyone else is going to find them when the time comes that they have to find them? Or I have folks who tuck them away in a safe deposit box. But at death, they lock up that safe deposit box if you don't have anybody else on the account. So then you have to go to court to get a special disposition to open the safe deposit box. Had a situation where, a lot of people wait till after the funeral to read the will. It's kind of gauche to read it, right away, and something bad happens. They opened the safe deposit box, read Dad's will, only to see that attached to the back of the will, he had said at his death he wanted to be cremated. And they just buried him. It's like, what do we do? And I'm like, in that case, I thought it was a money savings thing. Let him be, the kind of a miss. Oops. But you want to make sure the people who are involved know where the documents are. I have copies of them. Sorry, go ahead.
And maybe you discuss the documents before you.
Ideally,
need to, right?
wouldn't you? In a healthy family environment, I think you do bring in the key people that you want to manage, and even those you don't. Say, kids, here's the way it's going to be. If anything happens to me, I want your mom to take care of things for me. Anything that happens to her and she can't do it, I want you, number 2 son, to take care of it, and then after that, you number 1 son, then you number 3. And that's based on where y'all are located geographically, or based upon you're the doctor and you're the CPA and you're the other thing. But discuss it, because people are shocked at the end when they don't know and they get blindsided, or they're unable to serve. You'll want to know ahead of time. And for single folks who don't have children, it becomes a problem. Who's a good enough buddy to do all that for you if you can't take care of yourself? And for single people, it is a challenge. Oftentimes they go back to siblings, or they try to find that friend, or they're going to have to get outside paid help. And there's a way to do that, but you'll want to make sure that you have someone you trust, kind of being a trustee, to oversee the help that you bring in. And so there's a little bit more work to do, and I see this all the time with and it's oftentimes with the widow late in life. She didn't have children nearby, or doesn't have children that are responsible to do it, or never had children, and now on their own they've got to make the decision. And then with a lot of the people, especially, well, heck, a couple years when we first started our club, nobody was married. We all should have made those decisions on who's going to. We didn't want to talk about it, think about it, but we should, because if you don't, the court will then try to do what you want to do. And you know, the courts in Texas are pretty smart. I shouldn't say smart, but they pretty much do what you want them to do. Money doesn't go to the state. You know, people say, well, if you don't have a will, the money goes to the state. If you don't have a will, the state of Texas will basically give everything to your spouse. If you don't have a spouse, they give it to your parents. And children, if you have children first, and then your parents, you don't have, and then siblings, and then cousins. So it goes to your living relatives, kind of the way you probably want to do it anyway. The problem comes up when you have these modern marriages where he has kids, she has kids, then they have kids together, because the court doesn't know what to do with that. And they're afraid of the child being disinherited by the stepmom or stepfather. I had a situation where a family came to me too late to do anything. A woman had met a guy who had a son when the son was like 2 years old. Natural mom was out of the picture. She was in drugs and moved away and was gone. So they raised a child, and when the child was 17, dad passes away. They never got around to doing a will. The state of Texas wanted to protect the boy. So they said half of everything she had, because that's all marital property and community property state, half was his, half was hers. His half was all going to go to the son. Half the 401k, half the house, half the savings accounts. And mom's like, no, it should go to me, and when I'm gone, whatever's left goes to the son. I'm like, well, on top of that, they believed his interest and her interest were adverse to each other. So they had a court-appointed guardian to oversee any distributions from the money for the benefit of the son, which costs money because you have to pay these court administrators. Every time you go to court, take any money out, you have to pay someone as a trustee to oversee the money. And to make matters even worse, the kid was 17. He was having a hard time at 17. 17 is a tough age for a lot of kids. And he just lost his dad. He was angry. And he wasn't getting along. And mom didn't know how she was going to make it with only half of all the assets. And that's the way the law works, because they're afraid, well, mom's liable to go get married or give all the money to her kids and disinherit the child. So if you have children from previous marriages, or if you're involved with people who have children from previous marriages, by all means, you've got to do some of this estate planning. With that, I think we've said enough for tonight. I want to thank all y'all for being here, and see you next week. Ciao, ciao.